everybody. This is my latest video. I'm going to try and release them twice a week from now on. So this will be a Monday night release. And this is about do-it-yourself kangaroo courts. And this is part one. This is some foundational knowledge before we get into some ideas on things you can do once you get in there, if you get in there. So anyways, let's get going. Kangaroo courts are everywhere. Okay, technically they're all kangaroo courts unless it's a common law jury of your peers. Kangaroo court is a term descriptive of a sham legal proceeding in which a person's rights are totally disregarded and which the result is a foregone conclusion because of the bias of the court or other tribunal. And that's Black's Law Dictionary, 6th edition. All courts, there's two general kinds of courts. These are things we're going to cover. There's three general types of jurisdiction, what a kangaroo court is, why they're holding a kangaroo court, why they want you to have an attorney, and how to tell it is a kangaroo court and what to do in a kangaroo court, and how they're Satanists. That's what they are. It's all coming from the Vatican. The three different kinds of jurisdiction is admiralty, equity, and common law, or law of the land. There's a friend of mine that says that common law, there's different terminologies or different definitions of common law, and so law of the land is a more appropriate definition, and that's we the people. This is a common law court. The judicial power is the power to hear those matters which affect life, liberty, or property of the citizens of state. That's Sepulpa versus Land. And there's the citations there where you can find that. The very meaning of sovereignty is that the decree of the sovereign makes the law. We, the people, make the law. And that's what a trial by jury is all about. The jury calls the witnesses, questions the witnesses, determines the law and the facts in the matter, and even pronounces sentence. And the common law of England consists of 800 years of jury trial decisions. This is a Supreme Court case. And because it brings into action and enforces this great and glorious principle that the people are the sovereign of this country, and consequently that fellow citizens and joint sovereigns cannot be degraded by appearing with each other in their own courts to have their controversies determined. And that's a U.S. Supreme Court case. And so these courts that you see nowadays with the judge alone, those are all kangaroo courts. Okay, we have no business going into those courts, and they have no business trying to drag us in there. A trial by jury is not a trial with jury. That's what you see nowadays, is a trial with jury. They're admiralty courts, and a jury is there just to, put on a show trial. Trial by jury means that the jury calls the witnesses, questions the witnesses, determines the law and the facts in the matter, and even pronounces sentence. These days, all courts are of equity and admiralty. A court is the person and suit of the sovereign, the place where the sovereign sojourns with his legal retinue, wherever they may be. Black's Law Dictionary, 5th edition. A court, an agency of the sovereign created by it directly or indirectly under its authority, consisting of one or more officers established and maintained for the purpose of hearing or determining issues of law and fact regarding legal rights and alleged violations thereof, and of applying the sanctions of the law, authorized to exercise his powers in the course of law at times and places previously determined by lawful authority. And that's Black's Law Dictionary, 4th edition. Court, the king's palace or mansion, but more especially the place where justice is judicially administered. That's a cite from Coke's Commentaries on Littleton, Sir Edward Coke, in like 1500s. The superior courts are those at Westminster in England, and of courts some are of record and some not, which are accounted base courts in respect of the rest. A court of record is that court which hath power to hold plea according to the course of the common law, real, personal, mixed actions, where the debt or damage is 40 pounds. Okay, so the important thing here is a court of record is supposed to be common law, but when you got a judge by himself up there, it's a kangaroo court. I don't care if it's a court of record, it's still a kangaroo court, because he can do anything he wants. It's just recorded. That's all it is. That's taken from Tomlin's Dictionary 1835 edition. A court of record is, or where the proceedings are not according to the course, a court not of record is where the proceedings are not according to the course of the common law, nor enrolled in the county court or the baron court. Okay, and so that's again Tomlin's Law Dictionary 1835 edition. And that's again cited from Koch and his institutes. So a court not of record is where the proceedings are not according to the course of common law. So if it's not of record, then it's definitely big time kangaroo court. It's admiralty. There's two general types of courts. There's superior courts of general jurisdiction and inferior courts of limited jurisdiction. And how do you tell which one is which? This is a cite taken from 1835 Law Dictionary, Tomlin's Law Dictionary again. Excuse me. And also nothing shall be intended to be within the jurisdiction of an inferior court, but what is expressly so alleged, and if part of the cause arises within the inferior jurisdiction and part thereof without it, the inferior court ought not to hold the plea. And so, again, an inferior court is a court of limited jurisdiction. And if there's anything in that case that's not within the jurisdiction of the inferior court, they're not supposed to even listen to it. But they do all the time because they're kangaroo courts. A court of general jurisdiction is presumed to be acting within its jurisdiction until the contrary is shown. In other words, even a superior court of general jurisdiction does not necessarily have jurisdiction unless you give it to them. A superior court in some states is a trial court of general jurisdiction. In Pennsylvania, the intermediate court between the trial court and the chief appellate court. And what they're saying there is in some cases they actually call it a superior court. Arizona, they call it a superior court, but it's not whether it's called a superior court or not. It's whether it's a court of general jurisdiction. That's what determines whether it's a superior court or not. In Texas, they call it a district court. Anyways, that's taken from Black's Law Dictionary, 8th edition. A court not of a record, an inferior court that is not required to routinely make a record of each proceeding and usually does not. That's Black's Law Dictionary, 8th edition. An inferior court is a court of special, limited, or statutory jurisdiction whose record must show the existence of jurisdiction in any given case to give its ruling presumptive validity. And that's Black's Law Dictionary, 8th edition. And again, an inferior court is statutory jurisdiction, okay? And the statute is what spells out the limited jurisdiction. That's an inferior court, okay? And that in Canada, that's a provincial court. In Canada, the Queen's Bench is the superior court of general jurisdiction. In Texas, all the magistrates' courts in each city, that's an inferior court. Okay, the city court, that's a police court. That's an inferior court. In Texas, the superior or the district court is the court of is the superior court of general jurisdiction. Magistrates court, a court with jurisdiction over minor criminal offenses. Such a court has the power to bind over for trial persons accused of more serious offenses, also termed a police court. Okay, yeah, right. A court with limited jurisdiction over minor criminal and civil matters, and these are all taken from Black's Law Dictionary, 8th edition. The Admiralty, from the highest antiquity, has exercised a very extensive criminal jurisdiction. That's the U.S. Supreme Court. Admiralty courts have jurisdiction over contracts and torts and other special cases. Again, Supreme Court. Informations are filed with the Court of Exchequer for forfeiture upon seizure of property, for breach of laws of revenue, impost, navigation, and trade. And that's Kent's commentaries on lecture number 17 on Admiralty and Commerce. Okay, so Admiralty and Commerce are basically the same thing. Admiralty is contract law, basically, law of the sea, but it has to do with contracts. Informations, when these Satanist pigs assault you for speeding or something like that, then it's an information. That's always an information. These code enforcers, that's all they deal in is information. They're Admiralty. They drag you into their Admiralty court, and it's a kangaroo court. And anyways, you need to know that, and this is all part of determining whether you got a kangaroo court or not. An information is a written accusation of a crime made by a U.S. attorney which permits the government to prosecute an individual without benefit of a grand jury indictment. Okay, so again, a grand jury indictment is common law. Information is not. Information is required in any case where a person is being charged with an infamous crime. Well, yeah, they use informations all the time anyways. The Supreme Court ruled in Macon versus United States that any crime for which punishment is imprisonment is an infamous crime. Well, and so they put people in jail all the time based on an information. In short, prosecutions by information have long been a means of political suppression and intimidation. Okay, these people are Satanists. Okay, that's exactly what they are, and at common law, they don't want common law because they'd be put to death if it was common law. Okay, they don't want common law. That's the first thing they do is they get rid of common law by going bankrupt, and that's exactly what they do. These people are Satanists, and I know what I would do if I was the one in power. The use of information has a long history. For example, in the reign of Henry VII, a very oppressive use was made of them for something more than a century so as to continually harass and shamefully enrich the crown. It's always about money. Okay, that's Blackstone, Book 4. The oppressive use of this mode of prosecution by information occasions struggles to procure the declaration of its illegality. Well, yeah, it's illegal, but they still do it. And the right to be represented exists only in a military courtroom. This is why they want you to have a lawyer. Okay, it's a military courtroom. They want to shove that lawyer down your throat, and you're going to learn here pretty quick why. The accused has the right to be represented in his defense before a general or special court-martial at an investigation under Section 832 of this title, as provided in this subsection. That's Title 10, United States Code. In propria persona, in one's own proper person. It is a rule in pleading that pleas to the jurisdiction of the court must be pled in propria persona, because if pleaded by an attorney, they admit the jurisdiction. That's why they want you to have an attorney, people. That's exactly why, because once you have an attorney, then you just gave them jurisdiction. As an attorney is an officer of the court, he is presumed to plead after having obtained leave, which admits the jurisdiction. Okay, it's all Admiralty. Admiralty is based on presumption, and this is Black's Law Dictionary, 4th edition. That's why they want you to have one of their liars. The controlling rule is that absent a knowing, intelligent waiver, no person may be imprisoned for any offense unless he was represented by counsel at his trial. They want you to have an attorney so they can put you in jail. It's a presumption. They intend to put you in jail from the beginning. When the trial of a misdemeanor starts, that no imprisonment may be imposed, even though local law permits, unless the accused is represented by counsel. Those are 2 U.S. Supreme Court cases, people. He is, however, in a sense, an officer of the state with an obligation to the court. This is who an attorney is. Okay, this is Book 7 of Corpus Juris Secundum, Section 4 on attorneys. Okay, he is, however, in a sense, an officer of the state with an obligation to the court. His first duty is to the courts and to the public and not to the client. He has no duty to you. And whenever his duties to his client conflict with those as an officer of the court in the administration of justice, the former must yield to the latter. You got to watch my bar members' videos, okay? These people are Satanists. These people are diabolically evil. I would love to see them hanging by some tree somewhere. That's, if it was up to me, that's where they'd go. An attorney's client. Clients are also called wards of the court. Yeah, did you know that? That's also found in Book 7, Corpus Juris Secundum, Section 4. And a ward of the court is an infant or persons of unsound mind. So when you hire an attorney, you say, I'm an idiot. I want this attorney to represent me. That's exactly what you say. I am an imbecile. That's exactly what you're saying, people. Black's Law Dictionary, 4th edition. A ward of the court is an imbecile. A ward of the court is not competent. Everything is about competence and incompetence. That's why they're representing you, because you're not competent to make decisions for yourself. Therefore, the attorney is going to make the decisions for you. There is no such thing as an incompetent sovereign. Do you know who you are? All the forms and modes of proceedings and causes of equity and admiralty and maritime jurisdiction shall be according to the civil law. Okay, so Civil law comes from the Vatican. And all of these, admiralty, equity, maritime, is all pursuant to civil law. And that's the Supreme Court. Brown, Volume 2, 100, lays down the rules in these terms. The general rule, however, at present is that the Admiralty acts only in rem, and that no person can be subject to the jurisdiction but by his consent, expressed by his entering into a stipulation, a contract. They have to get you into a contract, people. Ramsey versus Allegory. U.S. Supreme Court again. In Krebel's report, page 500, quoted by Brown, it's expressly said that without a stipulation, the Admiralty has no jurisdiction at all over the person. And that's U.S. Supreme Court again. Contract. They have to get you into a contract. It's impossible to prove jurisdiction exists absent a substantial nexus with the state, such as a voluntary subscription to a license. All jurisdictional facts supporting the claim that supposed jurisdiction exists must appear on the record of the court. And that's U.S. Supreme Court again, people. It is a well-known that in civil cases and courts of equity and admiralty, juries do not intervene, and that courts of equity use a trial by jury only in extraordinary cases to inform the conscience of the court. And that's U.S. Supreme Court again. And what they're essentially saying there, people, is that a jury's there to give their opinion to the judge, but the judge can completely ignore it, and they do it all the time. Okay? They completely ignore juries, and it's a show trial. It's a kangaroo court. It has nothing to do with justice. There must be uniformity in maritime law. The principles of maritime law are applicable to commercial law, and therefore they must be uniform in commercial law. Commercial law and maritime law, it's all admiralty. It's all commercial. Swift versus Tyson. Civil law, and Roman civil law are convertible phrases meaning the same system of jurisprudence. That rule of action which every particular nation, commonwealth, or city is established peculiarly for itself, more commonly called municipal law, to distinguish it from the law of nature and from international law. And that's Black's Law Dictionary, 4th edition. Civil law, and civil law, Roman civil law are all convertible. They all mean the same thing. Admiralty law. The terms admiralty and maritime are virtually synonymous. And this is talking about what happens in an admiralty case. The technical niceties of the common law are not regarded. A jury does not figure ordinarily in the trial of an admiralty suit. The verdict of the jury merely advisory and may be disregarded by the court. The rules of practice may be altered whenever found to be inconvenient or likely to embarrass the business of the court. Yeah, right. Yeah, let's just forget about the rules because we don't want to have anything that resembles justice here. We want to railroad this guy. A court of admiralty acts upon equitable principles. A libel of information does not require all the technical precision of an indictment at common law. If the allegations describe the offense, it is all that is necessary. And if it is founded upon a statute, it is sufficient if it pursues the words of the law. So, again, there is nothing to do with justice that goes on in these courts. They are Satanists, okay? It's a kangaroo court. They're railroading you, and that's all there is to it. We can't even begin to count the number of times judges, lawyers, and statesmen have said there isn't any common law anymore. It has been replaced by statutes. They would be more truthful if they said there isn't any common law anymore. It's been replaced by martial law. Exactly. And that's Diet versus Turner, the non-ratification of the 14th Amendment by Judge A.H. Ellett of the Utah Supreme Court. Statutes have been passed for extending the jurisdiction of the courts of admiralty and vice admiralty beyond their ancient limits, for depriving us of the accustomed and inestimable privilege of trial by jury in cases affecting both life and property, and for altering fundamentally the form of government established by charter. We saw the misery to which such despotism would reduce us. And that's taken from the Causes and Necessities for Taking Up Arms, 1775. Equity. In the early history of the law, the sense affixed to this word was exceedingly vague and uncertain. This was owing in part to the fact that the chancellors of those days were either statesmen or ecclesiastics, perhaps not very scrupulous in the exercise of power. It was then asserted that equity was bounded by no certain limits or rules, and then it was alone controlled by conscience and natural justice. That's Blackstone's commentaries, which is cited in Bouvier's Law Dictionary. Now, that's exactly what they tell you today. Okay, you go into one of these kangaroo courts, and the judge will tell you, "I can do anything I want." Okay, that's exactly what they tell you, and that's exactly what they do. Equity. Chancery equals the Vatican. Equity, a court of equity, is one which administers justice where there are no legal rights or legal rights, but courts of law do not afford a complete remedy, where the complainant also has an equitable right. Um, so, an example of that is a mortgage. Okay, the bank has an equitable right. You have legal title. The bank has equitable title, and so, you know, the judge always goes in favor of the bankster thieves because they're bought and paid for by the bankster thieves. Equity, the system of law or body of principles originating in the English Court of Chancery. Okay, so remember I talked about chancellors in the previous site, um, and superseding the common law and statute law together, called law in the narrow sense. When the two conflict and appealing to the equity of the court, she's appealing to the king's conscience. Black's Law Dictionary, 7th edition. In the meantime, civil law was the form of law imposed in the Roman Empire, which was largely, if not wholly, governed by martial law rule. Equity has always been understood to follow the law. To have superior equity is to turn things on their head. This is exactly what happens when martial law is opposed. If equity is the law, then it follows its own course rather than following common law, thereby destroying the common law and leaving what's called equity in its place. And that's Diet versus Turner, non-ratification of the 14th Amendment again. In other words, what they're saying here is that when they go into martial law, it gets rid of common law, and then they can do anything they want. That's why they say, I can do anything I want here, because there's no common law. Okay, they can say, oh, this is a court of record. Oh, I believe you. I believe you. Really, I do. Millions wouldn't, but I do. And because it's even though it's a court of record, it's not a common law court. Okay, that's exactly what's going on here. It's at best you'll get some equity, and he can do anything he wants, and he's going to get a royalty. Okay, so 9 times out of 10, you're going to get railroaded. If you get justice in there, well, there is no justice. I don't care. Even if they rule in your favor, it's still not justice. Okay, even if they rule in your favor, it's still not justice. They're not competent to do justice. They are nothing but Satanists and thieves. Laches, French law. Okay, that's civil law. Remember we told civil law, Roman law, and Roman civil law are interchangeable? Well, that's French law. Unreasonable delay in pursuing a right or claim, almost always an equitable one. Okay, this is under equity in a way that prejudices the party against whom relief is sought. In other words, the thieves want to get away with their theft. And so if you go and that's why these Satanists went and passed statutes all over the place, even in Texas. You got to file a lawsuit within 2 years, or you lose your opportunity. The equitable doctrine by which a court denies relief to a claimant who has unreasonably delayed in asserting the claim when that delay has prejudiced the party against whom relief is sought. The doctrine of laches is an instance of the exercise of reserved power of equity to withhold relief otherwise regularly given, where in the particular case the granting of such relief would be unfair or unjust. Yeah, that poor city pig, he wants to get away with his theft. Yeah, that poor city pig. Anyways, that's taken from William F. Walsh, A Treatise on Equity, 1930, and which is cited in Black's Law Dictionary, 8th edition. The Judicial Code of 1911. Okay, that's found at 36 Stat 1087. Okay, and that's an act to codify, revise, and amend the laws relating to the judiciary. And it goes on, it says, being enacted in the Senate or House of Representatives of the United States of America, Congress assembled, that the laws relating to the judiciary be and hereby codified, revised, and amended with title, chapters, head codes. That's the first time they codified the judicial code, actually. Anyways, in section 9, the district courts as courts of admiralty and as courts of equity shall be deemed always open for the purpose of filing any pleading and issuing. And so the federal courts are all admiralty or equity. Okay, that's at best you'll get equity. These people are Satanists. They're kangaroo courts. Why do you think there's so many federal prisoners? They're giving you their equity. That's what they're doing, people. Chapter 2, District Courts, Jurisdiction. The district court shall have original jurisdiction as follows. First of all, suits of civil nature at common law or in equity brought by the United States. Okay, so at common law, at best you're going to get equity because there's no common law. They went and removed that when they filed bankruptcy. And arises under the constitutional laws of the United States or treaties under their authority, or B is between citizens of different states, or is C between citizens of a state and foreign state citizens or subjects. And what they're talking about here is when they're talking about states, they're talking about territories. Okay, those were all territories. Okay, and then foreign state citizens would be probably Texas. Okay, one of the real states. Okay, because what they're citizen of a state is those are territories. Okay, and I can show you court cases. Downs versus Bidwell talks about that. That territories are a state under international law. No district court shall have cognizance of any suit except upon bills of exchange. In other words, they'll only do um, Federal Reserve notes. To recover upon any promissory note or other chosen action in favor of an assignee, okay, a Federal Reserve note is basically a chosen action. Third, of all civil causes of admiralty and maritime jurisdiction, saving to suitors in all cases the right of a common law remedy where the common law is competent to give it, well, it's equity. And if you're lucky, you'll get, it's at best, you're going to get equity. Of all seizures on land and water not within admiralty, that's admiralty, obviously. That's at 36 Stat 1091. This is the international law rule adopted for areas under federal legislative jurisdiction. Federalizes state civil law, including common law. The rule serves to federalize not only the statutory but the common law of a state, and that's taken from jurisdiction over federal areas within the states. It's a report of the Interdepartmental Committee for the Study of Jurisdiction over Federal Areas within the States, Part 2, a text of the law of the legislative jurisdiction submitted to the Attorney General and transmitted to the President, June 1957. Okay, and so that's Congress, or Interdepartmental Committee for the Study of Jurisdiction over the Federal Areas within the States. That's Congress. And so, anyways, it goes on where they're talking about state and federal venue discussed. The civil laws effective of an area of exclusive federal jurisdiction are federal law, notwithstanding their derivation from state laws, and a cause arising under such laws may be brought in or removed to a federal district court. And so that's the same document. Okay, that part 2 is probably about 450 pages. Anyways, the point I want to make here is that all state laws are actually federal laws. Okay, because they only apply to U.S. citizens, and we'll go into it here in the next. It's every taxpayer is assessed to K trust having sufficient interest in preventing the abuse of the trust to be recognized in the field of this court's prerogative jurisdiction. A citizen of the United States is a civilly dead entity operating as co-trustee and co-beneficiary of the public charitable trust, the constructive Sestake Trust of U.S. Inc. under the 14th Amendment, which upholds the debt of the USA and U.S. Inc. That's taken from congressional record. It might be correctly said there's no such thing as a citizen of the United States. A citizen of any one of the states of the Union is held to be called a citizen of the United States, although technically and abstractly there is no such thing. Privileges and immunities of the citizens of the United States do not necessarily include all the rights protected by the first 8 amendments to the federal Constitution against the powers of the federal government. U.S. Supreme Court. The only absolute and unqualified right of a U.S. citizen is to resident within the territorial boundaries of the United States. That's, again, federal court. Citizenship is a political status and may be defined and privilege limited by Congress. The term resident and citizen of the United States is distinguished from a citizen of one of the several states in that the former is a special class of citizen created by Congress. So there's, in essence, what we're saying here is that there's 2 states in every state. There's a federal territory for U.S. citizens, and there's a state, a lawful state for state citizens. And there's been created a fictional federal state of XXX within a state, and that's Schwartz versus Township or Harrow Township School District, and that's a Pennsylvania case. Under an international law of warfare, all parties to a cause must appear by nom de guerre because an alien enemy cannot maintain his action during a war in his own name. Okay, so that's why they're spelling your name in all block capital letters. It's warfare. They're making war on you. A mixed war is one in which is made on one side by public authority and the other by mere private persons. Black's Law Dictionary, 5th edition. Capitis diminutio, meaning the diminishing of status through the use of capitalization in Roman law. a diminishing or abridgment of personality, a loss or curtailment of a man's status, or aggregate of legal attributes. Capitis diminutio maxima means a maximum loss of status, the highest and most comprehensive loss of status. This occurred when a man's condition was changed from one of freedom to one of bondage, when he became a slave. Okay, so when they're spelling your name in all block capital letters, they're saying you're a slave. Black's Law Dictionary, 4th edition. This is taken from the Trading with the Enemy Act, Title 50, United States Code, Appendix 5. The President, if he shall find it compatible with the safety of the United States and the successful prosecution of the war. Why do you think that they started the war on drugs? Okay, that was actually, I've got another YouTube video that talks about that, and that was actually Johnson had political enemies that he considered to be blacks and hippies, and he wanted to make war on them. And so that was the war on drugs. So what do you think is happening? Like the war on drugs is still going on, people, and now we got the war on terror. What do you think? You think Obama thinks that maybe anybody that thinks they have any rights is he's making war on them? Don't you think? Huh? What do you think? And what do you think? Do you think that's what's going on? That's exactly what's going on. Obama is making war on, and now they're calling anybody who's a prepper a terrorist, anybody that's Christian a terrorist. They're calling all sorts of people terrorists. Well, hello, people, it's time to wake up. During the time of the war, the president may, through any agency that he may designate, and under such rules and regulations that he may prescribe by means of instructions, licenses, or otherwise, regulate, direct, and compel, nullify, void, prevent, or prohibit, or exercise any right or power or privilege with respect to any property by any person subject to the jurisdiction of the United States. Okay, so they can basically steal anything they want. All persons born or naturalized in the United States are subject to the jurisdiction thereof and are citizens of the United States. And that's 14th Amendment. And this is an act to terminate certain authorities with respect to national emergency, still in effect, to provide for orderly implementation and termination of future national emergencies. This is the National Emergencies Act, approved on September 14, 1976 at 90 Stat 1255. And in Section 502, the provisions of this act shall not apply to the following provisions of law, the powers and authorities conferred thereby, and actions taken thereunder. And that's Section 5B of the Act of October 6, 1917. That is the Trading with the Enemy Act. Okay, so they went and repealed all emergencies except for that one, and it's still there. Diet versus Turner. In the meantime, civil law is a form of law imposed in the Roman Empire, which was largely, if not wholly, governed by martial law rule. Equity has always been understood to follow the law. To have superior equity is to turn things on their head. This is exactly what happens when martial law is imposed. If equity is the law, then it follows its own course rather than following the common law, thereby destroying the common law and leaving what's called equity in its place. So that's why they go and impose martial law, because they don't want common law around. They want to do things that they would be put to death over if they did common law. The exclusive jurisdiction which the United States have in forts and dockyards ceded to them is derived from the express assent of the states by whom the cessions are made. It could be derived in no other manner, because without it, the authority of the state would be supreme and exclusive therein. And that's true if you're a state citizen, but it's not true if you're a federal citizen. It is a well-established principle of law that all federal regulation applies only in territorial jurisdiction of the United States. And that's true if you're a state citizen, but it's not true if you're a federal citizen. There's a canon of legislative construction that teaches Congress that unless a contrary intent appears, legislation is meant to apply only within the territorial jurisdiction of the United States. U.S. Supreme Court, again, that's true if you're a state citizen. That's not true if you're a federal citizen. If a citizen acquires the same legal status as those protected by the amendment through the operation of some statutory law of Congress, then said citizen may be brought within the venue of the amendment as a statutory juristic person. By this means, citizens' birthrights become of no effect, and their rights are reduced to the inferior character of statutory civil rights. And that's, again, Judge H. Ellett of the Utah Supreme Court. A citizen, a U.S. citizen, is not entitled to an Article III court, but instead gets an Article I court with a plenary military dictatorship jurisdiction under Article I, Section 8, Clause 17, Constitution for the United States of America, as defined and reinstated in Natural Mutual Insurance Company of the District of Columbia versus Tidewater Transfer Company, which further states that citizens of the District of Columbia are not embraced within the judicial power under Article III of the Constitution of the United States of America. The same statement is held in Hep versus Dundas, In 1804, the Supreme Court, through Chief Justice Marshall, held that a citizen of the District of Columbia was not a citizen of a state. We therefore decline to overrule the opinion of Chief Justice Marshall. We hold that the District of Columbia is not a state within Article 3 of the Constitution. In other words, cases between citizens of the district and those of the states were not included in the catalog of controversies over which Congress could give jurisdiction to the federal courts by virtue of Article 3. In other words, Congress has exclusive legislative jurisdiction over citizens of Washington, District of Columbia, and through their plenary power, that's military dictatorship, people, nationally covers those citizens even when in one of the several states, as though the district expands for the purpose of regulating its citizens wherever they may go throughout the states of the Union. So, you remember that book about the international law where the federal jurisdiction applies in exclusive areas of exclusive jurisdiction in the states? Well, if you're a U.S. citizen, it's anywhere in Texas, okay? And if you're a U.S. citizen, it's anywhere in California, and it's anywhere in any state, okay? And that's U.S. Supreme Court. If any citizen or resident of the United States does not reside in or is not found in any United States judicial district, such citizen or resident shall be treated as residing in the District of Columbia for purposes of any provisions of this title to A, jurisdiction of the courts, and B, enforcement of summons. And that's where that is codified in the United States Code. The term individual means citizen of the United States or an alien lawfully admitted for permanent residence. The term federal personnel means officers, employees of the government of the United States, members of the uniformed services, including members of the reserve components, individuals entitled to receive immediate or deferred retirement benefits under any retirement program of the government of the United States. Okay, so that's found in Title 5, Section 552A. Now, the reason that is mentioned is because all they have to do to fabricate, anybody that has a social security number is a U.S. citizen, is government employee, okay? And so, and all they have to do is get you to give them like a date of birth, a name and a date of birth, and they can pull it up in their computer, and all of that is hearsay, okay? And so we'll talk about that in part 2 of this, okay? So right now we're just laying some foundational things to understand what the nature of what's going on, and then in part 2 we're going to talk about how you can deal with it in their kangaroo court. The term citizen of the United States is analogous to the term subject in the common law. State citizens are the only ones living under free government whose rights are incapable of impairment by legislation or judicial decision. State citizenship is a vested substantial property right. The state has no power to divest or impair these rights. The state cannot diminish rights of the people. In other words, when state martial law is imposed within the state to enforce national martial law, Congress has no reason to exercise its martial law powers. That's why all the states have gone past statutes that apply really only to U.S. citizens. But most people don't know it, and they get themselves mixed up in that stuff. If a state has conformed to the new order, there is no need for Congress to intervene, and if a white citizen has not obtained the standing of a former slave by petitioning Congress for admittance to venue and jurisdiction of the 14th Amendment, then Congress has no power over that individual under this clause. And so, but it doesn't matter what color you are, okay? Actually, it doesn't matter. Anybody can be a state citizen. And this is non-ratification of the 14th Amendment by Judge A.H.L. at Utah Supreme Court. Statutes have been passed extending the courts of admiralty and vice admiralty far beyond their ancient limits for depriving us of the accustomed and inestimable privilege of trial by jury in cases affecting both life and property, to supersede the course of common law and instead thereof to publish and order the use and exercise of law martial. And that's the causes and necessities for taking up arms. This is the kind of stuff that caused the War of Independence, people. Okay, that's exactly what I'm saying here. This is the kind of stuff that caused the War of Independence. He's combined with others to subject us to a jurisdiction foreign to our Constitution, unacknowledged by our laws, giving his assent to their acts of pretended legislation. Okay, well, gee, that sounds like color of law or martial law. For imposing on us taxes without our consent, gee, that sounds like color of law or martial law. For depriving us in many cases of the benefit of trial by jury, well, that's an Admiralty court. And this is taken from the Declaration of Independence. All of this stuff, this is the stuff that precipitated the War of Independence. And all of these, all statutes and codes are bills of attainder too. Okay. A bill of attainder means legislative acts, no matter what their form, that apply either to named individuals or to easily ascertainable members of a group in such a way as to inflict punishment on them without a judicial trial. And a bill of attainder, that's actually taken from, that's a Supreme Court case. This is taken from Black's Law Dictionary, 8th edition. A special legislative act prescribing punishment without a trial for a specific person or group. Bills of attainder are prohibited by the U.S. Constitution. A bill of pains or penalties is a legislative act, though similar to a bill of attainder, prescribes punishment less severe than capital punishment. Well, first of all, if they're converting your name into all block capital letters, that's a dead thing, and so that's effectively capital punishment. But even a bill on pains and penalties is unconstitutional under the Constitution. No one is bound to obey an unconstitutional law, and no courts are bound to enforce it, but they go ahead and do it anyways because they're collecting. It's all part of business. They want to get some revenue. That's exactly what they want to do. An unconstitutional act is not law. It confers no rights. It imposes no duties. It affords no protection. It creates no office. It is in legal contemplation as inoperative as though it had never been passed. And an unconstitutional law is void and is as no law. An offense created by it is not a crime. It never became a law and is as much a nullity as if it had been an act or a declaration of an unauthorized assemblage of individuals. So you have to understand that it's a clerk masquerading as a judge in there. Okay, all those must be lawful, allowed by common law or some statute, if they are administered by persons in their private capacity or not duly authorized. They are quorum non judice and void. Okay, that's Tomlin's Law Dictionary, 1835 edition. But they're also citing Coke on book 3 and book 4. And so the point is that all judges or all cops, all government officials can either be acting in their official capacity or they can be acting in their private capacity. If they go out, and this next site here, an officer who acts in violation of the Constitution ceases to represent the government. So if he's acting in violation of the Constitution, he's not representing the government. Okay? You have to understand that. So then he can't do anything. If it's a judge, he can't do anything judicial. If it's a cop, well, then he's impersonating a peace officer, isn't he? Okay, that's a felony in most states. Officers of the court have no immunity when violating a constitutional right, for they're deemed to know the law. Judge loses his absolute immunity from damage actions only when he acts in clear absence of all jurisdiction or performance of an act which is not judicial in nature. Okay, so when a judge is a clerk, he wants to become a clerk and masquerading as a judge, then he's not acting, he's not doing stuff that's judicial. So then he loses any immunity he had. When enforcing mere statutes, judges of all courts do not act judicially and thus are not protected by qualified or limited immunity. Okay, so if they're hitting you with a speeding, okay, that's not a judge in there, that's a clerk. Okay, masquerading as a judge, it's an imposter, and he cannot do anything judicial, and he doesn't have any immunity. And so think about it. That's the kind of stuff you need to bring up when you go in there. And this is taken from the Bible. Woe unto them that call evil good and good evil, and put darkness for light and light for darkness. That's Isaiah 5:20. If a man be found stealing any of his brethren, the children of Israel, and make merchandise of him and selleth him, then that thief shall die, and thou shalt put evil away from among you. That's why these people should be put to death. Okay, because that's exactly what they're doing. Is they're selling people into prison. Okay, there was a judge in Pennsylvania recently that was even convicted for that kind of stuff. He should have been put to death. Okay, and through covetousness shall they with feigned words make merchandise of you, whose judgment now the long time lingereth not, and damnation slumbereth not. That's 2 Peter 2 and 3. Patrick Henry coined the phrase "give me liberty or give me death" after he witnessed a man flogged to death for refusing to take a license. Okay, that's what these Satanists do. They assault you and kidnap you and falsely imprison you, and then say, "Oh yeah, he consented to all of this." By which he also went and preached to the spirits in prison, and it shall come to pass in that day that the Lord shall punish the host of the high ones that are on high, and the kings of the earth upon the earth, and they shall be gathered together as prisoners are gathered in the pit, and they shall be shut up in prison, and after many days shall they be visited. It behooves every man who values liberty of conscience for himself to resist invasion of it in case of others, or their case may by chance of circumstances become its own. That's Thomas Jefferson. If ye love wealth better than liberty, the tranquility of servitude better than the animating contest of freedom, go home from us in peace. We ask not your counsel or arms. crouch down and lick the hands which feed you. May your chains set lightly upon you, and may our posterity forget that you were ever our countrymen. And that's Samuel Adams. When shall it be said in any country of the world, my poor are happy, neither ignorance or distress is to be found among them. My jails are empty of prisoners, my streets of beggars. The aged are not in want, the taxes not oppressive. The rational world is my friend, because I am friend of its happiness. When these things can be said, then may that country boast of its constitution and government. Well, I got to tell you that the United States cannot boast of the Constitution or the government. Okay, that people are ignorant. The jails are full; they're overflowing. The streets are full of people begging. Taxes are outrageous, and more and more. Okay, so the United States cannot claim, "Oh yeah, we have such a great Constitution." Well, that it's a bunch of thieves that are in DC. Okay, their thieves are everywhere, and they're running the government. They're in all the cities, they're in the counties, and they're not all thieves, but there's a bunch of them, and their bar members are the biggest bunch of them. Okay, all of these Satanist bar members, that means these clerks masquerading as judges, and we the people need to put a stop to it, because otherwise we're going to be held accountable. But if the watchmen see the sword come and blow not the trumpet, and the people be not warned, if the sword come and take any person from among them, he is taken away in his iniquity. But his blood will I require at the watchman's hand. Okay, so my blood is clean. Okay, I've notified you. I've done everything I can to notify people, and so I am, doing what I can to make sure that I am blameless. Okay, I believe that I was sent into this world to be a witness of the abominations of this generation, and I am testifying of it. And either you're part of the problem or you're part of the solution. You are now a watchman. If you're watching this video, you are now a watchman. And circulate this video far and wide. And other videos that are coming, or that I've already done: Bankster Thieves 1, 2, and 3, Churchianity series, bankrupt corporate so-called governments, bar members, Unidroit, martial law is here. It has been for decades. Quasi-contracts and Roman civil law, de facto courts. All courts are ecclesiastical. DC courts in Texas jurisdiction. Copies of these documents can be found at my private group at Yahoo called Administrating-Your-Public-Servants. I have YouTube videos that are videos of private information shares that show these and other court citations that are available for a donation. Donations to support this work are appreciated. I prefer gold or silver coin, but as an extremely less desirable alternative, I can accept IOUs, Federal Reserve notes, PayPal gifts, checks, money orders, etc. Send me an email for particulars. If you find this useful, then you need to pay it forward. If you don't know what pay it forward is, then watch the movie. Okay, it's available to rent. My blog, and I've got a website. The blog is SovereigntyInternational.wordpress.com. The website, SovereigntyInternational.fyi. If you want to write any of this stuff down or check it out, I'd suggest you pause the video. Email, EngineerWin@Yahoo. YouTube profile, Sovereign Living. Community page at Facebook, and I got a private group. Yahoo private group at Administrating Your Public Servants, and a Google private group, Administrating Your Public Servants. So all of this information is free, but if you want me to babysit you, really, if you think about it, we all got ourselves into this situation because of our own ignorance and because of the ignorance of our parents. Okay, and so I provide this information for free, and you can get everything you need to assert yourself and to free yourself. But if you want me to babysit you, I'm not doing it for nothing. Okay, I'm not in this world to do it for nothing. Sorry. And so I'm going to need a donation. Anyways, I appreciate you taking the time to watch the video, and I hope you got something out of it. And I hope you have a real nice day. And I'm going to start trying to upload videos once a week from now on.